Good afternoon, everybody. My name is Tony Howard, and coming to you with some information that I trust and believe can help a lot of people, particularly in the county of Duval, state of Florida, city of Jacksonville. I came into some information that may be very useful to residents there, particularly those who may be under the impression that they have been convicted of a felony. Information will show that a lot of people there aren't, in reality, convicted of a felony. It's kind of a technical issue, but it's valid nonetheless. There are a lot of people right now who are in prison who this information might be valuable to. And because I'm concerned about those type of issues, particularly with African Americans, but not discriminating against anybody, I would like to impart this information on whoever may be interested. Let me first issue a disclaimer and inform you that I'm not an attorney. I'm not a so-called licensed attorney, even though no lawyers are actually licensed. There's no state or federal agency that issues an attorney a license. But I'm not an attorney. I'm only giving this information because I care and am concerned about the prison overcrowding issue, the disproportionate incarceration of African American men, women, and juveniles, and trying to offer a way for people to untangle themselves from the criminal justice system, especially those systems that are corrupt and unjust. So, in some sense, this information is being imparted in relation to the Black Lives Matter, imparted due to the my sentiments about the freedom struggle for Black people, civil rights issues. There's a whole assortment of things that this is related to, and I'm just hoping that it will be useful for somebody, and that others will join me in this quest of mine to liberate people from unjust incarceration and other issues related there too. Once again, I'm not an attorney, but I have done a lot of research. I have done a lot of study, and I ran into some information in my effort to help out a friend. We did some research together, and I found out certain things with those coming out of the 4th Judicial Circuit of Jacksonville, Duval County. First, I'd like to make you aware of a certain rule. Now, in order to be convicted of a felony, the court must issue a judgment. And I have a piece of paper here. I'm not sure if you can read it. It may be kind of difficult to read, but it concerns a judgment. And the Florida Rule of Criminal Procedure, Rule 3.650, states that the term judgment means the adjudication by the court that the defendant is guilty or not guilty. Adjudication by the court is important because most people, when someone asks you if you've been convicted, they normally think of it as a plea bargain, or you were found guilty by a jury of your so-called peers. But adjudication must be made by the court. And this rule defines what a judgment is. It's the adjudication by the court. Always remember that. That is by the court. The jury may find you guilty on the facts, but in order for a judgment to be rendered upon you, it must be made by the court. My issue today is to let you know that for the past 30 years or more, that no court in the 4th Judicial Circuit, particularly that in Duval County, Jacksonville, no court has made an adjudication of guilty over the past 30 years. And that affects, literally thousands and thousands of people from, like, say, 1975 up until today. All the people that have come through that court system and been accused and somehow factually been found guilty of a felony have not actually been adjudicated by the court as guilty of a felony. Now, I'm gonna go through some technical rules right now, but a lot of people get off, especially the rich and those who can afford good attorneys. They get off cases or they escape punishment based on technicalities. And that matter can apply to you too. So I want you to listen carefully, and above and beyond, above all, let's say, do your own research. Take the information that I'm giving you, go to the books, Google the information, go to Westlaw or Lexis or any other social information engine or internet engine that you can, and look this information up. Okay, we're going to go next to Rule 3.670, which is entitled a rendition of judgment. A rendition. The judge has to render judgment. He has to render it in order for it to be effectuated. And the first paragraph reads as follows. If the defendant is found guilty, a judgment of guilty, and if the defendant has been acquitted, a judgment of not guilty shall be rendered in open court in writing, signed by the judge, filed, and recorded. I'm going to read that again. If the defendant is found guilty, a judgment of guilty, and if the defendant has been acquitted, a judgment of not guilty shall be rendered in open court in writing, signed by the judge, filed, and recorded. So there you have it. In order for you to be found guilty, the judge must sign the document. It must be filed with the court, and it must be recorded. Next is a law. This law has been enacted by the Florida legislature. And the particular law that I'm bringing to you is 921.241, dealing with felony judgments. 941.241, felony judgment. And it reads as follows. Every judgment of guilty or not guilty of a felony shall be in writing, signed by the judge, and recorded by the clerk of the court. Read that once again. Every judgment of guilty or not guilty of a felony shall be in writing, signed by the judge, and recorded by the clerk of the court. Now, this statute goes on to prescribe something in particular. This is a command to the court, not a command to you or to the jury. This is a command to the court, to the judge who represents the court. And it reads as follows, and please pay particular attention because this is highly important to the matter that I'm about to reveal to you. The judge shall cause to be affixed to every written judgment of guilty of a felony in open court in the presence of such judge at the time judgment is rendered, the fingerprints of the defendant against whom such judgment is rendered. The fingerprints shall be affixed beneath the judge's signature to such judgment. I'm going to read that once again. The fingerprints of the defendant against whom such judgment is rendered, the fingerprints shall be affixed beneath the judge's signature to such judgment. Beneath such fingerprints shall be appended a certificate to the following effect. Quote, I hereby certify that the above and foregoing fingerprints on this judgment are the fingerprints of the defendant, and that they are placed thereon by said defendant in my presence in open court this such and such day of such and such year. Such certificate shall be signed by the judge, whose signature thereto shall be followed by the word judge. That's 921.241. Now, as you can see, this command by the legislature to the court commands that the judge sign twice. He must sign the adjudication of guilt, and beneath that signature, that's why I emphasize the word beneath. Beneath that signature comes the defendant's fingerprints. And then a certificate follows the fingerprints, which also must be signed by the judge. So that equates to 2 signatures. One for the adjudication of guilt, one certifying that the defendant's fingerprints were taken in open court in front of the judge. The judge must then again sign. Now, for some unknown reason, perhaps it was a gift from God, I'm not sure. I can never say. But, matter of fact, let me do this first. Here's an illustration. This is another rule from the rule book, demonstrating, and this is promulgated. This is handed down by the Supreme Court of Florida. Here's an illustration in the rule books, and you have to go look this up so you won't just take my word for it. In the rule books, there's an illustration of how the judgment must be signed. Now, at the top, you see a place for the judge's signature. It's got a little star right beside it. The judge must sign there, and underneath, like they said in the statute, beneath that signature, the defendant's fingerprints must be placed. And then you see the certification. The judge must certify that those fingerprints were taken in open court. He's certifying now that he saw the bailiff or whoever take your fingerprints and place them on the judgment sheets, and then he signs again, just as the statute illustrated. So the rule of court promulgated by the Supreme Court of Florida backs up the legislative will. The statute tells the judge what he must do. In Duval County, however, the clerk of the court or whoever passes out or hands out the judgment forms took away the judge's ability to adjudicate you guilty of a felony. Here's a copy of a judgment from January 17th, 2002. And on the first page is from the 4th Judicial Circuit Court in and for Duval County, Florida. I've redacted the names and numbers on there to protect the identity of whomever's judgment this is. But you can go and check your own if you've been ever found or ever been prosecuted in Duval County. You can check your own judgment form. And this is very important for you to do because it could save you a lot of heartache, a lot of misery, and could perhaps even get you paid if you follow through long enough. But anyway, here's the paper. On this page 1, there is no particular place for the judge to sign. In fact, you can see right here, the judge can find you guilty or not guilty. But he must sign this form. He must sign it. But on page 1, there's no place for him to sign. All he can do is put a check mark on there as to whether or not he found you guilty or not guilty. As a matter of fact, here's the place. Here's a place up here and down here. All right? But a judge cannot find you guilty or adjudicate you guilty with a check mark. of that same judgment form, here's page 2. Above the fingerprints, now remember the statute said that he must sign, that the fingerprints must become beneath the judge's signature. So the signature comes first and then the fingerprints. Well, above these fingerprints, in the forms coming out of Duval County, there's no place for the judge to sign. But yet the fingerprints comes afterwards, and then there's the certification, right? That he saw somebody put these fingerprints on this paper, and then he signs. His signature is in that little circle there. Hope y'all can all see this. Now, if there's no place, and if the judge failed to sign the adjudication of guilt, then that means he never adjudicated you guilty of a felony. Now, I have personally checked dozens of these forms. And out of every one I checked, coming out of that particular county, out of that particular court, Duval County, Jacksonville, Florida, not a one, has ever been signed according to the statute, according to the rule of court. The only thing these judges have done was certify that the defendant's fingerprints were taken in open court. That means that thousands and thousands of people have come through that court and have not been lawfully adjudicated guilty of a felony. What does that mean? What's the ripple effect of this omission? It means that if you were denied registration to vote, if you were denied a license because of a felony, or denied a job, denied food stamps, denied public assistance, denied the right to custody of your children, denied a grant to attend college or higher education or any technical or vocational trade, that you have been wrongly denied, that you're entitled to these because you do not have a felony record. Furthermore, if you have been subjected to a second prosecution and you either pled guilty or went to trial and you were subjected to an enhanced sentence, and that is like if the crime carries 5 years but you got 10 because of the enhancement, or if you got 10 and got 20 because of the enhancement, and the enhancement must be based on the adjudication of what they call a predicate felony. Now, there are a lot of guys, a lot of women, men, women, and children in jail right now serving time for enhanced sentences, that have never been initially found guilty or adjudicated guilty by the court of a felony. Now, you can skip over this matter if you want, but I'm saying it's affecting a lot of people. It's affecting a lot of the results of a lot of elections. It's affecting people who can't feed their kids, or people who can't eat themselves. They come out of prison, they can't get food stamps, or they can't get a grant to go to school because they're under the false impression that they have a felony. Some can't get jobs. And this information is being proliferated through different law agencies and what you call those Equifax and other criminal background checks, and they're accusing you of being a felon when in actuality you have not been. So I think this is very important in the community. Now, the thing that bothers me is that I have written to black newspapers. I have gotten in contact with political activists. I have gotten in contact with religious groups, all kinds of people from all walks of life telling them about this issue, and it seems like nobody listens and nobody seems to care, although they continue to complain about prison overcrowding. They continue to complain about brutality of the prison system. They continue to complain about all sorts of issues dealing with incarceration, how people are profiting, from prison overcrowding, all these issues. And this is a issue related to all of that. Now, why do I go into that? Because there's yet another law. That law is Florida Statute 944.175. Why is that important? Because this particular law commands the Florida Department of Corrections not to incarcerate you if this and other documents are incomplete. If this document has not found you guilty of a felony and it remains unsigned in the proper place by the judge, then it is not complete. The word is not correct. The operative word is completed. If the documents are not completed, then you have not been found guilty of a felony, and the statute commands the FDOC to check the paperwork once you hit the door and to refuse to accept you into the prison system until these documents are completed. Well, what does the FDOC do? They let you in, because 9 times out of 10, or 9.5 times, or 9.99 times out of 10, they know that you don't know about these incompleted documents. The statute is explicit, specific. It explicitly tells them not to let you into the penitentiary if this and other documents are not complete. And they have a whole list of documents that the FDOC must have, and those documents must be completed. And then is at that point, once they check it and see that they're complete, they can let you into the system to start serving your time. But they're not doing that. They're allowing you in anyway. They know that these documents are not completed, as well as the court. But they know also that you don't know. And if you fail to check, and if you fail to complain, then they'll just let you in, do what they do to you, and subject you to all these punishments without lawful process. So it's up to you. Now, I'm just a lone wolf crying in the wilderness. I've been trying to do my part as a citizen and as a black man to impart this information upon everybody. I'm not discriminating on who I'm giving it to. That's the purpose of this video. Yes, I'm trying to help African Americans, become more aware of, some of the indiscretions of the criminal justice system. But I'm not discriminating. I'm imparting this information to anyone who's willing to listen. Now, that goes into another era, another realm of false imprisonment, false incarceration. The system is just taking advantage of us, of our ignorance. And, the Bible says that, my people suffer for a lack of knowledge. So here's the knowledge. I'm giving it to you. Almost the entire, no, I can't say the entire, I'll say 40, maybe even 50% of the black population in Jacksonville, Florida has been felonized. They're having election issues because a lot of people are being kicked off the voter rolls because they're under the false impression that they have a felony. So this has, all kinds of effects, and a lot of these things can be remedied if people would just, open up their minds, their eyes and ears, and go check on the paperwork. These things are not signed; they're not worth the paper they're written on. But this is what's holding you back. So go check it out. You can contact me at tone.howard5656@gmail.com. If you have any comments, I appreciate you leaving it, on the video, or any questions. I'm willing to guide you in the right direction. I'm not an attorney. I'm just, just a guy who cares and who loves the law, loves studying law, reading cases, reading statutes, trying to find out the reason behind things. And like I said, one of the reasons why this second law that I told you about, the one dealing with the Florida Department of Corrections, one of the reasons why the Florida legislature enacted this law is because there used to be a time when sheriffs and wardens would snatch men off the street and throw them straight into prison, no judicial process whatsoever. And the person in prison couldn't prove to anybody else that he didn't belong there because, there was no paperwork. And so once, this was a prevalent thing at one time. And so the legislature came up with this law so that if somebody challenged their incarceration, there would be a paper trail of completed documents to show that that person belonged in prison, or if he challenged correctly that he didn't belong in prison. So they gave the Florida Department of Correction or the prison system explicit instructions: do not allow this person into the penitentiary unless he had completed paperwork, because somebody could make something up, give it to the warden, and he'd throw you in prison and keep you there for the length of the so-called sentence when actually no sentence had ever been rendered. So that's why this language, this legal language, is explicit, and they make commands to certain people, particularly those to protect the citizen and to protect the Department of Corrections. So, I'm giving you this information. It's pertinent. I've researched it to the hilt. I got case law that shows that if this judgment is not signed, if no judgment was ever rendered with the judge's signature, then your case is still open. The trial court maintains jurisdiction over that case. If you had an appeal on it, the appeal doesn't count because the appellate courts cannot hear a case that was never completed or never finalized in the trial court. The appellate court cannot hear that case. Any judgment that they rendered on your appeal is null and void because jurisdiction still rests with the trial court. So look into this information. It can help a loved one if it can't help you. Contact me, tone.howard56@gmail.com. Get in touch. In the meantime, peace out, stay safe, and God bless. Thank you. Let's see, baby.